Okay, part 2 is legal aspects of patient care, and a lot of this is similar but focuses on the responsibility of a dental hygienist legally to a patient and that relationship. So the objectives are here. I'm going to be talking a little bit about some legal matters as well as the professional obligations and malpractice. So the dental hygiene patient relationship, it is a committed relationship between the two parties. It has to kind of have an agreement or of participation from each member. Patient comes with expectations, certain expectations, and the dental hygienist must understand and acknowledge those expectations. The dental hygienist is obligated to abide by the law that governs our practice and our scope of practice, and we've learned a lot about that, and to deliver oral health care services that meet the standards of care of our profession. So we have certain standards of care that we have to be aware of and keep up on as things progress and change so that we can be giving our patients the best care possible. A dental hygienist who fails to fulfill this professional obligation could face something as simple as a complaint investigation or something more serious like disciplinary action from the board or something very serious such as criminal penalties. Legal framework of the relationship. So it's really a legally binding relationship. When somebody goes to a healthcare provider, they're going there expecting all sorts of medical advice, medical help, or dental help for them to understand and explain to them what's happening with their body and to help them heal and regain health. And this is not only sort of a situation of trust, but it's also a legal situation and a legally binding situation based on society's belief that citizens have the right to be protected. So this goes back to the first couple weeks of our class when we were talking about ethics and autonomy and people's individual rights. So civil offense is failed to provide or an example of a civil offense could be you're failing to provide periodontal therapy to a patient that has active periodontal disease. They come to you, you can tell that that's what's happening, and instead you minimize it and you just provide them with a prophy and you don't mention to them that they have periodontal disease. An example of a criminal offense would be practicing dental hygiene without a license. A violation of criminal law is a violation of a societal rule outlined by statutory law. So that's oftentimes a much bigger deal and has a higher penalty. So our legal system is pretty much divided into two sorts of structures, civil cases and criminal cases. And they're similar in a lot of ways, but civil cases have a plaintiff and a defendant. Then there's witnesses, there's a trial, a judge and jury. But a criminal case will have a prosecutor and a defendant, witnesses, trial, judge and jury. So you can see the main difference there is civil cases have a plaintiff, criminal cases have a prosecutor. Questions of law are decided by judges. So if it's a question of the law, the judge makes the decision. If it's questions of facts, they're decided on by the jury. So there's two major categories of civil law, and that's contract law and tort law. So a contract is a legally binding agreement to keep a promise in exchange for something of value. The court views the relationship between a healthcare provider and a patient in terms of a contract. So you're keeping a promise to exchange something of value. They're paying for medical services. You're telling them and you're diagnosing them in good faith and telling them all of your expertise, helping them through treatments and deciding which treatments to take and medications. in exchange for money. Dental hygienists agree to provide oral health care, and the patient agrees to cooperate in the care and arrange appropriate payment, may be expressed or implied. So this could be something that's written, it could be something that's implied. It depends on what exactly is taking place at what stage. So a breach of contract, failure to meet one's contractual obligation. So next we have tort. So this definition here is a little bit tricky to read through and understand, but basically, instead of it being a contractual obligation where we set down all these perimeters and you said you would do this, if I did that, instead of that situation, tort stems from society's expectations of your performance. So it's a breach of a legal duty that exists by virtue of society's expectations. So things that are sort of normally expected, that maybe a virtuous, moral human being, or things that we just expect to happen in society. So that's tort. It can be intentional or it can be unintentional. And so we'll look at this a little bit more. So intentional tort to persons, this is on purpose, could be battery, harmful contact with a person. Example of that, a dental hygienist threatens to stab their patient with a scaler. They may be guilty of assault. So, you get a patient that drives you crazy and you're mad enough you want to stab them. I doubt anybody will do that, but if they did do that, then that would be an example of battery. Misrepresentation, incorrect or false representation. So this could be, say, a dental assistant goes back to dental for dental hygiene school, and on break or something, the dentist says, "Hey, come on back, and you've learned enough. Come back and clean some teeth for me." And so they, before they have their license, they go back and work as an RDH. So that would be misrepresentation. So intentional tort to property, physical invasion on land without authorization. An example of that would be finding a coworker who lost a handpiece and keeping it as your own property instead of giving it back to them. And let's see, if dental hygiene treatment results in injury, the patient may seek compensation through the court. So the three most common actions related to healthcare are failure to obtain informed consent, professional malpractice, and a breach of contract. So what is malpractice? So dental malpractice, failure of an oral health care provider to exercise the degree of care, skill, and learning expected of a reasonably prudent oral health care provider in the class to which he or she belongs in the state, acting in the same or similar circumstance. So that's a mouthful, but basically if Dr. A and Dr. B act this way, then we expect Dr. C to do the same. If this is their reasonably prudent oral health care provider and they're in the same class as all the other doctors, then everybody should be acting the same or similar under similar circumstances. So malpractice may be established if the provider is found to have violated the standards of care. So we have these standards of care in dental hygiene that we're expected to follow. And if we go outside of that, we go below it, we don't reach those standards of care, then that is considered malpractice. Example of that would be failing to obtain a comprehensive health history. So it's very common. This is the standard of practice, standard of care, to go through and get a comprehensive health history, make sure that you know their background as much as you can, for as honest as the patient is willing to be, and as much as the patient knows their own health history. But we have a standard that we try to attain all the information that we possibly can. Shared responsibility. So I have no idea how to pronounce this word well. Respondent. superior. The employer acts through their employees. So this is like the dentist representing his dental hygienist. It's not uncommon for a dentist to be the sole defendant in a case of injury resulting from care delivered by a dental hygienist. Fortunately, there are very, very few cases where hygienists have gone to court. There are some, but very few in general. And there are cases where the dentist is the sole defendant because that's where the dental hygienist is sort of under the umbrella of the authority and the supervision of the dentist. So sometimes it's actually the dentist's license that's in trouble. So statutes of limitation, this limits the period of time within which an injured party can file legal action, usually ranges from a couple of years, 2 to 4 years, and it protects against stale claims. So you can't go back and say, hey, you know what happened 4 years ago? I want to sue because of that now. So there's a limitation when something can be brought to the courts. Breach of contract. The most common breach of contract occurs when a healthcare provider guarantees an outcome that does not end up occurring. So promises that can't be kept. So example of that is, we might not think about this. This is something, pretty common that we might say just offhand, like, oh, this is an easy procedure. There's nothing to it, says the dental hygienist. And then that patient ends up with a huge abscess, the root canal fails, and they end up losing the tooth or something. So we really can't look into the crystal ball and say how a procedure is going to turn out. We know that in general things have low risk of certain, but there's always exceptions to the rule, and so you can't emphatically promise that something will turn out a certain way to a patient. They always have to know the risks involved. Dental hygienist and the patient relationship is a two-sided relationship. There's rights and responsibilities on both sides. Dental hygiene has an ethical and legal obligation to uphold the standards of the profession and avoid injuring the patient. But that ended right there. But the patient also has to uphold their side. They have to uphold their financial obligation, and then they also have to uphold following through with treatment and acknowledging what they can do to help with their health when we give them the recommendation. So it really is a two-sided relationship that takes both parties to get the best result for the patient. Okay, and that's the last one.